recording. So tonight we're going to talk about the process of writing an opinion and a little bit about different types of opinions. And so we're going to spend about the first 30 minutes talking about, you know, now that you've read the chapter stuff and the things from the Judicial Writing Manual about writing an opinion and the organization of the opinion, let's start thinking about how that relates to being a good opinion writer, relates to being a good writer generally, and how it relates to being a good judge. And then after we talk about that, I'm going to show you guys a video. It's pretty long. I think it's incredibly interesting. I hope you guys will too. It's a panel discussion with 4 or 5 judges talking about opinion writing, basically, sort of what their thoughts are on opinion writing, what their process is on opinion writing. And so it's a way for you to get some input from active judges about the task that you are going to be completing toward the end of the semester. And so it's some expert advice. And generally, I'm not a big video shower in class. I think I show 2 videos a year. But I really struggled with it because I like to make sure that you guys get bang for your buck when somebody takes one of my classes. But I really think this is worth the time. And I questioned whether if I assigned it for you outside of class, if that was going to be a good idea or effective. And I decided that in a summer class where everything's so compressed anyway and that you're so short on time, I didn't want to give you a 1-hour video to watch outside of class. And I thought it was sufficiently useful. I watched the video, and I'm actually looking forward to watching it again. I thought it was sufficiently useful that it was definitely worth our time. So I'm going to show that to you guys after we talk a little bit. I want to start with talking about, and one of the primary benefits, I think, of this class is that it gives you an opportunity to really think about some things that we don't often have a chance to pause and think about. For this class, it has to do with, sitting in the judge's chair and thinking about, as I go about my business as a judge, what does it mean for me to do a good job? What does it mean for the advocates in front of me to do a good job? And then for you to be able to take that into your advocacy as you go forward, and to have new insight into how to represent your client in front of these people with this task. Another thing I want to say to you, June 21st, we're going to be talking about the role of the clerk. And we're going to have 2 guests with us that day. One is Deborah Lannon. She is the current law clerk to Judge Arlene Lindsay. She's a trial level clerk. She's going to be with us talking about what it is like to be a term clerk, meaning she has a set number of years that she can do this job, and then she goes on and does something different. And then we're also going to have Carol Geary with us. She's a law school classmate of mine. She's a career clerk in the Dallas Court of Appeals in Texas, and so she's going to talk to us about what it's like to be, an appellate clerk in a state system and as a career rather than just as a couple of years at a time or a couple of years immediately after law school. So we should get a lot of different perspectives on being a clerk. And so what we're going to do is have just sort of a panel discussion with the team first and then open it up for your questions. And so this is one of the things we get to do with this class, and it's harder to do with the mortar class. Somebody is doing construction in the background. Is that Kyle? Kyle?
Sorry, I was having problems with my internet connection.
Okay. Can you mute while you're doing that?
Yep.
I don't know what word I was going to use. That's fantastic. Okay, and so now 4, 3, 12. We're still missing somebody, I think, but I'm going to go ahead and take attendance. So the first question I want to ask you guys is, what are the, hold on, I lost my notes. Let's talk about what the characteristics are of a good judge. We talked a little bit about that the other day, but I want to talk about it specifically in the context of writing opinions. What makes a judge effective in drafting opinions? What do you guys think? Yeah, Tiffany. Tiffany, I think you've got yourself muted on your end.
Can you hear me? I can't.
Yeah, maybe can you turn your volume up a little bit?
Can you hear me now?
There you go, that's better.
Okay. So the Leibowitz article had mentioned that judges write opinions for many reasons to help think through the issues. So they basically have to explain to the parties, their counsel, and the appellate courts how and why the case was decided.
Okay.
So they have to basically speak to various audiences, and they have to tailor their opinions, I'm thinking, to those audiences.
So what is that characteristic? That's a task. What kind of characteristic do you have to perform that task?
I'm lost for words.
Okay, think about it.
Okay.
Chris?
Hi. I was going to say persuasive writing.
Okay, so a judge has to be persuasive.
Yeah, and give their reasons to justify why they came up with the outcome that they did.
Okay, well that's a task. What is the characteristic? What is a characteristic of someone who can articulate their thoughts well? Jacqueline?
Educated would be a good.
Okay.
What I have written down.
Okay.
Educated and well-spoken, someone that is articulate, like you said, so they could give a good answer.
Okay. Jeff?
I would say the judge has to be thorough.
Okay.
And make sure that he applies the rule to the facts, and also unbiased when he gives the facts.
Okay.
He makes sure that he's not swaying one side or the other. He's just giving the facts and then applying his opinion based on.
Okay. So you said thorough, but you bundled into it, I think, a couple of thoughts.
Yeah.
Not only thorough, both in the process of arriving at the decision, seemed to be what you were saying.
Yes.
And in the process of articulating the decision.
Yeah.
So thorough throughout the process.
Yeah.
Okay. And then another thing that I'm hearing, nobody's using the word, but what you're describing is someone who is deliberate and methodical. Does that sound right? Okay. So deliberate and methodical. Any other thoughts about what characteristics we want from our judges? Okay. So now let's think about specifically writers, not necessarily judicial writers, but any writer. A writer we enjoy reading, either a journalist, a fiction writer, a historical writer, a judge, anything. What are the characteristics that you think would make somebody a good writer? Yeah, Rachel? Oh, Rachel, hold on just a second. I'm going to unmute you. There you go. Oh, sorry. I unmuted Rob. Where? Oh, there you are. Okay, go ahead. Sorry.
For writing, you want it to be clear and direct and, easy to understand, something you don't have to reread a bunch of times.
Well, so that's the writing. What about the writer? What do we want from the writer?
I guess frank and blunt honesty, direct.
Okay, so you want an honest writer. You want a direct writer. Yusun.
What I'm thinking is a writer making audience happy or sad through reading.
Okay, so audience directed. Okay. Kyle.
You want like a writer who has the ability to actually interest his writers. You know, like if you don't want a writer that's boring and you read his articles and it doesn't enthuse you at all and you don't want to finish it.
Okay, so interesting. Rob. Oh, hold on, Rob. You're still. There you go.
So yeah, I think someone else kind of said this, but kind of like the almost like knowing what the reader wants and how to answer their question.
Okay. Okay. Very good. So, someone with some insight into their reader. Is that what you guys mean? Yeah. So, reader insight. Some knowledge and understanding of the audience. Jacqueline.
I was going to say creative, which is kind of along the lines of interesting, is what I was going with.
Okay.
So uses creative language, something that's going to intrigue you. Maybe like different I like when I learn new words in cases and I have to go to the dictionary and look it up.
Okay.
So stuff like that.
Okay. John.
You just want to stick to the relevant and the pertinent facts. You don't want to include anything that is irrelevant. You don't have to address every single thing. Also, you want to make sure that you avoid any sort of personal attacks or some sort of appearance of bias, things like that.
Okay. Excellent. Tiffany.
I was thinking along the lines of, well, it depends on what you're reading and what they're writing. So I like to read autobiographies. So I want the autobiography to be very honest. I want to hear all the gritty details, but I also want it to be told, the story to be told well. I want like a good storyteller. But if I'm reading like fiction, then I want it to be like creative and like out there and, you know, different things. So they have to, I guess, cater to whatever they're writing, cater to the audience.
Okay, so proficient in whatever, insightful as to their audience, but also proficient in reaching that audience.
Yeah.
Yeah, skilled. Chris?
Yeah, I was going to say kind of similar to what John said, a writer who fully understands the issue or the subject at hand.
Okay, so knowledgeable.
Right.
Great. Okay. Now let's talk about the characteristics of a good opinion. What are the characteristics of a good opinion? What's an opinion that you read and you get to the end of it and you're like, that was interesting, I understood it, I'm happy, I can move on with my life. Jacqueline?
Anything written by Scalia.
Scalia, why?
You know, I just like the way he writes. He writes with interesting words, and he always has like interesting, like one of the cases that I'll never forget is he related the case to the zombie apocalypse.
Uh-huh.
And it was just like, it was completely asinine, but it was something that you were just like taken aback, and you actually kind of you understood where he was coming from.
Okay.
What he was trying to say.
So colorful and vivid.
Yes.
Yeah. Okay. Tiffany?
To add to what Jacqueline said, I'm not sure if this was Scalia, possibly might have been Scalia, but we read a case in con law where the opinion refers to the Bill of Rights as a penumbral effect.
Mm-hmm.
And when I understood that and when that made sense to me, I was like, wow, that's pretty cool. That's why I like, this is interesting. So I like the fact that they did that.
Okay, so it's something that teaches well.
Yeah, and they related it to something like everyday life that, we had to look it up, but once we looked it up, we understood it and it related well with us.
So it was accessible.
Yeah.
Okay, great. Chris?
Well, First, I was thinking I like when it opens with a good comprehensive understanding of where they're going and what the issues are. And then along with that, too, I was going to say when they identify the issues clearly.
Okay, so a good roadmap, clear identification of what it's going to cover and where it's going to go and what order it's going to take things in.
Yes.
Yeah. And I see a lot of you nodding. Yes, we would like that. That would be good. Catherine, what do you think? Oh, unmute. I got you.
When an opinion is clear and concise and transparent so that you understand when they make a point, or when the judge makes a point, where they're coming from, what law it's based in, so that I don't like opinions where they throw so many cases in there. Some of them don't even have any relevance. They actually are rebutting that case, and you have to decide where are they coming from. I like it to be transparent and directive to where they're getting their decision from.
Okay, so one that has done competent selection of authority.
Right, limited and direct and concise.
Okay. Okay. Rachel.
When an opinion definitely has picked a side, I don't like when the opinion sounds like they're going either way. I like it to be very clear.
Okay. So again, sort of what Rachel was talking about, sort of what Catherine was talking about, and what Chris was talking about. You want it to be transparent. You want to know, you don't want to wait till the end to find out, and then here's who we held in favor of.
Right.
You want to know from the beginning. Why is it that you guys want to know that at the beginning? Why not wait till the end? It's more fun. You find out at the end. It's like a Grisham novel. It's like Gone Girl. The opinions could be like Gone Girl. Why don't you want that?
Because you want to get right to the point. I think direct is better. You don't want to, it's not the trial, it's the opinion.
You're not reading it. You're not along for the ride.
Right.
Like you are when you read a novel. You're not along for the experience that the reader wants to provide. You need something, and you want to be able to find it. So, it's almost as if, you were looking up a word in a dictionary, and you looked up one word, and it said, ha-ha, see this word. And you went to that one, and it said, ha-ha, see this. It's like, I'm not just trying to see what what you want to experience you want to give me. I need something specific. I need to control this experience.
Right.
Yes.
Yeah, I was actually going to say pretty much what you said, and I was just thinking, when you go on any adventure, you want to take a map with you so you know where you're going and what you're going to be able to find.
Yeah. Okay, any other characteristics of a good opinion? So we want it to be, another word I thought for what you guys are describing is predictable. You want to be able to use the opinion. You want to be able to know what's in there and be able to navigate the opinion. Okay, so let's look at kind of some common themes we see between what makes a good judge, what makes a good writer, and what makes a good opinion. All of them had some aspect of being knowledgeable. We want that from our writers. We want it from our judges. We want it out of our opinions. You all said in all three of them some version of articulate and clear. So for all of those things, you want some clarity. In addition to that, for the judicial writing specifically, you wanted stuff that was unbiased. You said that in both as the opinion and the judge. And then let me look at another one. Yeah, and then user-friendly seemed to be another one that you wanted a judge, a writer, and an opinion to all have to demonstrate some insight into the reader, what the reader wants, what the reader's interested in, and what the reader needs. And then I would also add, because this came out a couple times, skilled. what's interesting to me about a lot of the things you said about the opinions is some of them are really the exact opposite of what a lot of young legal writers think they ought to be doing. A lot of young legal writers, and by young I mean like first semester of law school, that early on your inclination is often to try to use the biggest word possible or the most complex sentence structure possible, or to not give away the answer until the very, very end, or to provide all of the cases you found everywhere and not just pare it down to exactly what you need. And so, so that's one thing to reflect on, is that, you know, our instinct sometimes as to what a smart writer does is really the complete opposite of what a busy reader needs, you know. And of course, as you guys have discovered in your first year, and those of you who are beyond your first year have discovered this for sure, it's harder to do it. It's harder to make it look simple than it is to make it look hard. And that is really the judge's job. The judge's job is to make it look simple so that people can use that writing. Because of course, the audience for the opinion isn't just the parties, although they're certainly the first ones who are going to be interested. As you guys well know, the audience is 5, 10, 15, 20, 30 years down the road from the writing of the opinion. And so the writing really has to stand up over time and really has to be able to stand on its own without the author explaining anything. Okay, so toward that end, I want to talk about judicial writing as it relates to the writing that you've already done, because hopefully what came out as you did the reading was that the format of a judicial opinion, and of course there's not one set format, but the general format for a judicial opinion is exactly what you've been familiar with. There's some identification of an issue, there's some identification of the applicable law, there's a statement of the applicable facts, and then there's an application of the law to those facts, and then finally a conclusion, which in this context tells the reader what the decision is. And a lot of us also like that conclusion at the very beginning. You know, we find for the plaintiff for the following reasons, and then you have the opinion. And so some of you like that C at the beginning and at the end. I know I like that at both places. So there's not really, you know, like I could spend, we could spend a week or more talking about the nitty-gritty of how to write the judicial opinion, but you already know that. And so let me show you exactly what I mean by you already know how to write a judicial opinion. My computer is run entirely by gerbils. There's gerbils and a wheel behind it. That's what powers the whole thing. Hold on. I'm going to show you something. Or, hold on. Sorry, I'm back. Hold on. Okay, well, maybe that'll work out later, and I'll show it to you afterwards. But what I want to show you is a chart that contains all of the basic analytical documents that practitioners write, and show you how an opinion fits into that, so that you can see more clearly. And if I can't get it to come up tonight, I'll just post it on Twin, and you can take a look, to show you that each document has the same basic 5 sections, and that is a caption or a heading of some kind, and that's certainly true with a judicial opinion. You've got the style of the case and the date of the decision and all of that part. Some sort of identification of the issue and some answer to that issue, a statement of facts, an analysis of some sort, whether it's an an evaluation or a discussion or an opinion, and then some sort of conclusion, either that wraps things up only, or that wraps things up and then tells what's next. And a lot of conclusions in legal documents tell what's next, either by asking for something, saying what's going to be given, or suggesting to someone that that they do something next. So a judicial opinion is exactly the same. And so all of the things that make a good analytical document in general also make a good judicial opinion. And so next week and the week after, we're going to talk a little bit specifically about just good legal persuasive writing. We'll talk first about who it is that judges are trying to persuade and how do they do that best. And then the next week I'll do a class called Power Writing, which is a CLE that I do for practitioners, that's just sort of down and dirty, really effective, a technique for really good, effective writing that will help you with the judicial stuff. Because as you guys have identified, all of the skills you need to be a really good opinion writer are skills you've already learned. What you need at this point is just sort of the added perspective of the judge. So we're going to start, keep your fingers crossed, we're going to start with this video. Let's see if it's going to let me show you. There it is. Oh my God. It's working. I'm a little scared. Okay. I'm gonna hit go on the video. When it goes, give me a thumbs up and let me know you see it moving, that we've actually got some moving video here. Yay. And I can still see you guys. So if you have a problem with anything, just wave at me or send me a chat message. And don't take your clothes off or start smoking weed. I'm right here.
This is C-SPAN's America at the Courts. Next, Supreme Court Justice Samuel Alito at Pepperdine University Law School.
You guys all got audio?
California. He took part in a discussion on writing judicial opinions and how clear writing advances understanding of the law. This is an hour portion of the discussion.
The conversation tonight about judicial opinion writing and its craft is one that is remarkably understudied. While there are some important seminal works that were written on this topic by Judge Ruggero Aldisart of the Third Circuit, and that have been updated most recently in a separate book by Judge Richard Posner of the Seventh Circuit, it's not a topic that has greatly occupied the time of law professors in terms of the regular curriculum, and it has not also been a topic featured by professional societies in terms of bar associations either, and that's rather remarkable given the significance of these opinions and the importance both for the parties in the cases, of course, to get a clear judgment, for the lawyers in practice to have that type of coherence for the ability to give guidance to their clients, and for those of us in the classroom who like to know what we're teaching. So we're happy to have the opportunity to explore the various aspects of the craft. And you'll see in the course of the discussion that we will be asking questions about the role of the judge, about the purpose of writing judicial opinions, what gives those opinions legitimacy, what the role of dissenting and concurring opinions are, what role empathy and considerations of non-judicial matters have with respect to the writing of opinions, judicial method and philosophy, and so forth. And we begin, Justice Alito, with a characterization of the judicial role by one of your colleagues, indeed the Chief Justice. It's now a relatively famous characterization. He told us all, in assuming his responsibilities, that he was going to be an umpire, and that no one would notice him because no one goes to a ball game to see the umpire. You are a big fan of ball games as well as the Chief Justice, I imagine. But this characterization of judges as umpires is one that has been disputed over time. Indeed, Justice Brennan wrote that judges were not umpires, but rather they, in their own sphere, and I quote, they were lawmakers, a coordinate branch of government. Justice Frankfurt said that judges were not umpires, they were instead the conscience of the law. What's your take on the characterization of the judicial role, and in light of the way you see your own role, how does that affect the way in which you draft an opinion?
I've actually given an entire speech on the issue of judges and umpires, and I'm not going to give it today because it would take up the entire time. But in defense of umpires, I have to say that their role is not as mechanical as a lot of people think. They really exercise a lot of discretion. In fact, even more discretion in some areas than judges should exercise. But I think what the Chief Justice was getting at was simply an analogy and not anything that he intended to be exact. Obviously, there are important differences between umpires and judges, but I think what he was getting at is a very valid point, which is that umpires have rules to apply, judges have rules to apply, and it is our job, just as it is the job of the umpire, to apply those rules, not make up new rules, and not assume a role that is broader than, different from the one that people expect us to perform, that our Constitution and our society expects us to perform.
So it's a rule-based assessment then that the Chief Justice was attempting to emphasize, that in fact you're not drafting the law, you're interpreting the law. If that is the case, how does that show up on a day-to-day basis as you're crafting opinions?
Well, let's take the issue of interpreting a statute. It was not that long ago when perhaps the most famous Court of Appeals judge in the history of the United States, Learned Hand, and I'm not going to get this quotation exactly correct, but the thrust of it was the best way to misinterpret a statute is to read it literally. And I think he said you shouldn't make a fortress of the dictionary. That was the dominant school of statutory interpretation not that long ago in our history. Now, I don't think that we do that in that way any longer on the Supreme Court or on the Courts of Appeals. We start with the language of the statute. That's the rule that we're applying, and we pay close attention to that.
Judge McConnell, your insights on the role of a judge and the characterization, this umpire or non-umpire analogy?
Well, I don't know about that particular analogy, but I do think that in our system, the judiciary plays an important role. But when people begin to see the courts as the primary decision maker with respect to controversial matters not addressed, say, by the Constitution or by the statutes, it's an indication that perhaps the courts are overstepping their role. The Constitution has a number of very important principles in it, but it does not answer all questions. And when we see major areas of American political life dominated by court decisions rather than by decisions of the representatives of the people, I think something has gone awry.
Would you say that scholars who have written about judicial opinion writing have suggested that its essential purpose is the statement of a justification for a decision reached? Is that a sufficient explanation for what you see your writing task as being when you write an opinion?
Well, I think the important thing about an opinion is that it can, at least properly understood, be a form of discipline for the courts. The courts are the only institution of our government that are required to state the reasons for what they do. Now, of course, other actors, the president might make a speech explaining something, congressmen might do the same, but the judges give opinions as part of the formal process, And the opinions, I think, they expose whether the judges have a proper grounding in, text or history or precedent or whatever happens to be the mode of analysis. But when you read the opinions, anyone reading the opinion can make a judgment for themselves as to whether that decision was actually a conscientious application of those authorities. And I think that that's a major form of discipline. I know it happens to me at our lowly level, as I'm in what the Constitution charmingly calls an inferior court judge, and at that level, I know that it regularly happens that I think a case can and should be decided in a particular way, but when I sit down to actually write the reasons why, I find out that it won't work. And now that does not make, at least I flatter myself that doesn't make me, write it in a sort of sneakier, more Machiavellian fashion to make it come out that way anyway. It makes me say, well, we ought to reconsider this and come out the way it's going to write in a straightforward, authoritative fashion.
Now, on both the Supreme Court and on the inferior court, there is a collegial process, right? This is a collaborative process. You're mostly sitting in panels of 3. You, of course, are sitting in a panel of 9. As we understand the Supreme Court's deliberations, following the oral argument, and we have 2 great oral advocates here, following the oral argument, the justices or the panel assemble together to deliberate and vote. And a vote is cast, and then the assignment for the writing is given in the Supreme Court by the Chief Justice if he's in the majority, by the Senior Associate Justice if he's in the majority. Is it a little unusual to vote first and write second? Some people looking at that process from the outside, and indeed one of your own number, Judge Posner, in his book on how judges think, argues that there's a real risk in writing after voting because there's a tendency to want to confirm the way you voted. Is that a problem?
Well, I think as a practical matter that this isn't really as true as all of that. Maybe our court, the 10th Circuit, is more collegial than some. But yes, we vote, but that is not fixed in stone. We vote, somebody goes off and attempts to write an opinion. If one of the members of the panel disagrees and says, I'm going to write a dissent, the other members always wait. They consider the dissent. We think about it. It is not unusual. It doesn't happen every day, right? But it is not unusual for the case to come out differently than the initial vote. It sometimes comes out unanimously different than the initial vote because of the crucible of opinion writing and commenting on upon the opinion. So the conference, our conferences are very frequently quite substantive. Depends in part on the personalities of the judges, how much they like to engage in back and forth, but they're often quite substantive. But that's just the beginning of a deliberative process that doesn't, it's not the end. It's not as if you vote and then everything else just follows from that.
Professor Dellinger, you had some recollections of your own days clerking on the Supreme Court for Justice Black. And what was the nature of the deliberation that took place as you saw it as a law clerk during those days? And do you think the deliberation on the Supreme Court today is the kind that produces this debate among the justices, this consideration and reconsideration to make sure that they're actually making decisions based on text and history? And
I was surprised in 1968, 69 at how little the justices discussed cases collegially outside of the conference. They tended to operate like 9 separate law offices. The other thing I learned that's pertinent to the the question Judge McConnell was answering is that I spent a lot of time looking through the files about prior years of the court. And it is a disproof of the cynical notion that judges are not influenced by the law and the arguments. To look at the number of times, not large, but significant, that the result changes between the time the case is argued and a tentative vote is taken and the end of the process when people have considered all of the opinions. Because when you cast your first vote, you know everything that would bias you. You know what the politics of the case are. You know whether it's a corporation or a criminal defendant, who's on what side. It's only when you look at the opinions are you influenced by the doctrinal considerations and the fact that people change their votes and the result changes because they are influenced that sometimes the draft of the dissenting opinion has the better, more convincing argument as I think an existence proof that law goes on and it's not just politics in another name.
Dean Starr, you've just returned from our London program. Welcome home.
Thank you.
And among other things, the English had a tradition of what they called oralty, which in appellate practice meant that there were no briefs. The judges knew nothing of the case until it was presented to them. The oral argument in an appeal would last a week or more. This sounds delightful. The judges would be sitting on the bench reading the statutes, cases, and authorities for the first time. Some of us have witnessed this English tradition and seen the materials being handed up, and of course these long pauses as people study. The English idea of this practice was, of course, full transparency and public accountability. Both of the members of the bench have indicated that there's a fair amount of deliberation going on. That's the recollection of Professor Dellinger. Would it be a good idea if the internal deliberations were made public after a case was decided?
It would be a horrible idea.
Why so?
We need confidentiality. The law and any number of relationships says that confidence is going to be protected. The lawyer-client privilege, the spousal privilege, the priest-penitent privilege, all these developed at the common law to do what? To protect relationships. And the Supreme Court of the United States has recognized with respect to public officers, most famously in the case involving Richard Nixon, United States versus Nixon, that confidentiality is a vital part of our governmental system, but they were relying not on some abstract philosophy, but on common human experience. It was a very pragmatic reflection on the way institutions operate and people operate. And so to encourage a confidential, robust exchange of views, you've got to know that it's not going to then appear in a professor's website 2 years later or in the pages of the New York Times. Confidentiality encourages this kind of deliberative exchange that is very important for the healthy operation of the institution.
Just a one added comment. The court is said often to be the most secretive of our institutions. I think that maybe have it backwards, because what matters about the court's work are the opinions that are publicly announced. Whatever a judge or justice's sort of secret agenda may be, what is the influence that controls the law is what is said in a fully public opinion. So in some sense, what matters is first the arguments, the inputs are all public, and what matters is the justification for the, for the decision. That's what guides the future, not any, express reservation. So I've never felt the need to know what led up to the public opinion.
I take it you concur in this matter of keeping these things confidential.
I do. I have to say that I think it was last year we had a visit from the Chief Justice of the Supreme Court of Brazil, who's a very, very impressive person. And she astonished us by saying that in Brazil, the conference of the Supreme Court is televised. And we said, well, that can't be the real conference. There must be the conference before the conference that's on television. But she swore that that's the way they do things. But I entirely agree with what Dean Starr said. I think that it would undermine the decision-making process.
Can you tell us a little bit about the manner in which deliberations in the modern court takes place? Is it by email? Is it by telephone? Is it by memoranda? Or do you speak through law clerks? Or which is the most frequent way in which you're interacting with your brethren?
Well, on my old court on the Third Circuit, a lot of it was by email because we were located in different places. On the Supreme Court, we are not yet into the email era. We do almost nothing by email. It's mostly done in conference. We talk about the cases in conference, and then we talk about the cases through the medium of the opinions that we circulate and comments on the opinions that are circulated.
Have you had occasion to be assigned writing an opinion and it didn't write, and so you then sent a memo around to your colleagues saying, guess what, I'm now in the dissent?
Yes, certainly. During my time on the Court of Appeals, it happened a number of times. And on all of those occasions, actually, the rest of the panel ended up agreeing with it. But what Judge McConnell says is entirely correct. There are opinions that just will not write. There's a great discipline in having to write out an argument, no matter how thoroughly you've thought it through before you put it on paper. You inevitably see things when you sit down to write the opinion, and sometimes it causes you to change your mind.
Now, there's a lot of people waiting on the words at the Supreme Court and their Supreme Court opinions and lower court opinions as well. There's, of course, the other justices who are waiting to see what you're going to circulate. There's the parties who are waiting to see the outcome of the case. There's the lower courts, the political branches, the administrative agencies. There's the states, and there's the New York Times. As you're writing,
and don't forget all the blogs.
And the blogs. As you're writing, are you thinking about the blogs?
I'm actually not thinking about any particular audience when I'm writing. I have an idea in my head about how an opinion should look, and basically that's what I'm doing. But if I stop to break down the process, I think I am first writing for myself in the sense that Judge McConnell said, setting out an argument that I find convincing. Then I'm definitely writing for, if I'm attempting to write a majority opinion, I'm writing for the other justices or judges who I hope will be part of the majority. I have to write the opinion in a way that embodies something that we can agree on, something that I think we will agree on based on our discussion at conference. Then I'm certainly writing for, with the hope that this will be an opinion of the court, I'm writing for those who will have to apply the opinion in future cases. Trial judges, lawyers who need to work with the opinion. There's an unusual aspect of opinion writing in that something that I don't think authors in most other genres deal with, and that is we are writing in part for an audience of people who will not try to understand what we really mean, but will try to use our words to support whatever position they, in a professional way, use the words to support whatever position they feel they need to take on behalf of a client. So it requires a special degree of precision, and I think you have to keep that in mind.
Judge McConnell, any thoughts about these various audiences that may be reading your work?
Well, at our level, we do not get the same kind of scrutiny. There are not that many law review articles that are coming out and parsing our opinions and so forth. I'm one who thinks that commentary and critique is actually a useful thing for the courts. I wish often that it were more professional rather than just in the nature of, well, we don't like the result in the case. I mean, particularly at the Supreme Court level, I think there's been an enormous amount of the commentary on the court's work is as if the vote had been taken in Congress, and the question is, did you like how they came out or not? And by the way, we're here in a law school, and I'm a former, even to some extent, a current law professor. I think that the academy is letting us down in a sense, is not performing as useful a function as a commentator as it might, because too many law professors are political or ideological first and legal and professional only second. The question should be whether, as a legal matter, what the Supreme Court or any other court is doing is well grounded. It should not be whether we happen to like the result. And when the Academy, who are our best, ought to be our best friends and our harshest critics at times, when they act more like politicians or advocates, then it makes their commentary essentially useless as part of the disciplining function. And I was going to say, at my level, we don't get as much scrutiny. I wish we had more.
Should the Academy be spending more time analyzing the 10th Circuit's work?
I think so, but
Never get tenure.
That's happen. But I made a joking reference to blogs earlier. I actually think blogs in the legal area are beginning to provide this kind of commentary, not on the 10th Circuit, but on particular subject matter areas, so that there are very useful blogs maintained mostly by academics, in some cases by practicing attorneys, on specific areas of the law, where they look and they comment upon decisions from district courts and courts of appeals, not just the Supreme Court, but the inferior courts as well. And in many cases, this is the best, most intelligent, most professional commentary and critique that we get. And I'm quite grateful for that, and I think that's been an excellent development in the last several years.
Vincent Blasi, a law professor, has observed that one of the most important audiences the Supreme Court has is the lower courts, the courts that have to then apply the rule that you've articulated. There's been several major cases decided in recent years. I think of the past term's decision in Boumediene, the case dealing with the writ of habeas corpus and its applicability to non-citizens being detained in Guantanamo, where the Supreme Court's direction to the lower courts has basically been, have at it, fashion an appropriate response to meet the constitutional considerations that we've articulated. Is that the kind of direction that the court should be giving the lower courts? And given the wide berth that you've given to the lower court in that circumstance, how does the Supreme Court monitor, if at all, what the lower courts are now doing in response to your ruling?
I wasn't in the majority in so I'm not going to try to defend that. I was the recipient of Supreme Court decisions, in a sense, that the applier of them for 15 years on the Third Circuit. And what I was looking for was some clear expression of some clear guidance as to what I should do. And I was always happy when I received that, and not so happy when the guidance wasn't so clear. But there are trade-offs in writing opinions, as there are in everything else. I went to a dinner during the course of the year for new judges. Whenever there's a body of new judges, there's a school, what they call baby judge school. They go to this school in Washington, and there's a dinner at the end of it, and a district judge spoke. A new district judge and a new circuit judge spoke. The district judge, I think, had been a state trial judge for many years, and he was a very he was not an inhibited guy in any way. He commented about an opinion that we had just issued, and he said that, I won't get into the specifics, but he said this involves an issue that we apply all the time in the trial court, and we were waiting for guidance on this issue, and because we just wanted to know what we should do in future cases. This comes up with some frequency, and we got the opinion, and we saw that it was a unanimous opinion, and then we read the opinion, and we found out that it really didn't tell us what we were supposed to do in particular circumstances. Well, there are trade-offs. If you want to have a unanimous opinion, it may not be possible to be as specific as you could be if you didn't aim for that unanimity.
Well, in fact, that's one of the things the Academy has noticed, and that is that there is this seems to be growth in the distinction between facial and as-applied challenges, that to some degree the greater consensus, as you just alluded to, is a consensus built upon, for example, in the Indiana voter ID case that Justice Stevens, I believe, wrote the majority opinion for, that he was willing to defer to the legislative choice in Indiana that they could have their ID card to suppress fraud that didn't seem to exist in the record in Indiana but may have existed in some other states. But on the supposition that it would be possible later to come back and see if this ID requirement was unduly burdensome for the disabled or unduly burdensome for the elderly or for the poor or others who couldn't get to the DMV. And that showed up, did it not, Dean Starr, in a number of places?
Why are you picking on me on a specific case?
It did, as you recall.
As I recall. As you can tell, this is unrehearsed. And your question is?
Well, my question is...
I thought that was a question for Dean Dellinger.
I have a baseball fan friend on the Supreme Court. That was a curveball. It was headed to Dellinger, and it broke right.
That was a slider.
Well, is this development of upholding statutes on their face a good development, as you see it?
I think so, because it does say to litigants and to judges, be very careful, be very cautious. Let's give this legislation a chance. Let's look at whether this legislation, a law passed by the people's elected representatives and signed by a governor or Congress and signed by the president, whether it can have a constitutional application in any set of circumstances. That's a pretty tough standard to try to meet. That's asking a lot. And so the court has been saying, we do ask a lot, so give us your best arguments. And even there, in a case that was very politically charged, Judge Posner, writing the majority opinion in the voter ID case for the lower court, said, hey, this is a Republican-Democratic kind of issue. People are just going to line up based on their party. Well, I think it was wonderful to see Justice John Paul Stevens, who, whatever his party affiliation was once upon a time, whether he's a D or an R, here he was saying, no, we're judges, and we're going to say, bring us specific examples of what you called an unduly burdensome application, but we're going to set the standard very high in order to actually tear asunder a statute that the legislature and the governor of the state thought was good legislation to encourage integrity in the process. So that whole case had been so politicized, and here were these voices from the Supreme Court saying, let's depoliticize this, look at it, as Judge McConnell would say, in a much more professional, dispassionate way. And so one of the, to use the jargon, most liberal members of the court said, I am not going to cast my vote to strike this law down. Let's see how it operates. It was a very practical and I think very respectful decision in terms of the democratic process.
Right. So the benefit is it respects the legislative outcome and the democratic outcome. You see a downside?
Well, I do in two senses. One, when you decide cases on an as-applied basis, you're really not deciding lots of other applications, which is good, but you're not, when you deal at a larger level of generality, you're answering a lot more questions. And it's not just lower court judges that need guidance. And it's state legislators in a search and seizure area. It may be a county deputy sheriff. Now, there'll be a court somewhere in the process with that county sheriff, but the doctrine has to be one that can be written in terms that it can be actually followed. I've seen law professors or law clerk colleagues write about the probable cause as if it were an essay in epistemology. and how do we know what we know? But you actually need rules if you're going to be a police officer and apply it. And I respectfully disagree that it's also bound up with the merits. It's not just technique. If you think that that the ID requirement is an unnecessary burden on a process that shouldn't be burdened at all, if that's your view of the voting rights as it is mine, then you don't need to go to the as applied, because your substantive view resolves the issue for you. And therefore the as applied is in some sense secondary to what you think of the merits of the case.
Judge McConnell, are you getting sufficient guidance in these cases that are being resolved in this fashion?
It's nice to get clear guidance, but in a way that's not my highest priority. What I'd rather have them get it right. And it's to my mind, it is much more frustrating for me as a lower court judge to apply decisions that I think are incoherent or counterproductive than it is to deal with vague decisions. And there are even sometimes when I think vagueness is the right thing to do. When the courts are venturing into new areas, very frequent, it's so difficult for mere mortals to guess what the range of problems and issues that they're going to be that come up. Sometimes it really is better for the court just to say go at it, and then all the various complications of human life that will throw themselves up in lots of different cases, and the lower courts can sort through them, and it may become much clearer how we should deal with this than it is for the Supreme Court the first time they confront a problem to try to think that they have the ability of writing a set of rules for it. I think the court sometimes does us a disservice by jumping the gun and trying to issue a bunch of clear rules on when we don't yet know enough and there hasn't been enough experience, and so whenever one thinks about the interpretation of the writ of habeas corpus in the Guantanamo detainee cases, and whenever one, as a matter of history and precedent and so forth, I think it may have been the best thing about the decisions that they did not attempt to say, and by the way, here are all the possible ramifications and rights and applications. We don't know. So I think that a bit of modesty there was a good thing.
The bookend to the opinion that is written for the person that's got to apply it on the lower court or in the operative field is an opinion, particularly in the Supreme Court in great cases, that is really written for the long-term future. That it's clear that some opinions justices are thinking about people long after they have passed from the scene. I'm struck, for example, that when John Marshall wrote McCulloch against Maryland, articulating a view of national supremacy and the importance of the nation, that opinion was read by a young lawyer starting out in practice in Springfield, Illinois, who was deeply impressed by it. And one can't help but think that had some influence on what Abraham Lincoln thought needed to be done to preserve the Union, that he had read John Marshall's opinion. So sometimes opinions are reaching very far into the future to shape views of the polity.
I want to remind the audience that there are helpful people, I think, patrolling with 3x5 cards, so that if you do have questions during the course of the proceeding, and you look and you think that your moderator is struggling and you want to help him out, just write something coherent on the card, and or a little smiley face or whatever you like, and we'll try and work it in. I want to turn at this point.
Well, I have one of those, so I'm curious.
Good luck.
We're talking about the reception of Supreme Court opinions among lower courts, and lower court judges talk about Supreme Court opinions all the time. They're helpful, not helpful, confusing, not confusing, whatever. Something I'd be curious to hear Justice Alito's reaction to is do the Supreme Court justices appreciate lower court opinions pointing out problems with jurisprudence?
Very much if they point out problems with other people's opinions.
Well, that goes without saying.
No, they are helpful in pointing out problems and pointing out problems and applying opinions, pointing out problems that might not be apparent to someone other than, let's say, a trial judge applying an opinion, or a court of appeals judge who has to deal with a great many opinions raising factual variations under a particular legal standard. To point out the problems that arise in those contexts in particular, I think is quite helpful.
How influential are lower court opinions in particular in persuading the justices to take a case?
I think they're very influential. They highlight that if there's a dissent, it can highlight the problem with the majority opinion, the importance of the issue. So it is a very important factor.
And do you do the same in reverse? Do you put people on notice about particular problems in your opinions? I remember Justice Rehnquist in the VMI case, I think, said that the state of Virginia should have known that gender discrimination in that context of public education should have been understood by the state of Virginia to be impermissible from the Hogan case, for example. I mean, is the court in the business of sending signals out to political actors or to others?
There are some contexts where that comes up. I don't know that it's happened much in my own experience.
I seem to recall you wrote the Hine decision, if I'm recalling correctly. That was an example of, I believe, a number of separate opinions from the Seventh Circuit. Were those, I take it this is an example of the kinds of lower court identification of an issue that the court finds helpful.
Yeah, exactly.
I want to turn to a question from the audience, which will take us off on a bit of an interlude. It's a question about Justice Thomas and whether or not Justice Thomas will ever engage in oral argument or not in the argument, in oral questioning.
He's explained his view of oral argument, and he doesn't find it too helpful to him to ask questions, and I think each of us approaches our work in a different way, and he certainly analyzes every case very thoroughly and could ask questions if he chose to do so. He's a very forceful and active participant in conference. Oral argument in the Supreme Court has changed quite a bit. It has not always been the way it is now. I noticed a big change from when I was arguing cases. When Judge McConnell and I were in the Solicitor General's office in the 1980s, there are many, many more questions now. In those days, there were quite a few justices who rarely asked a question, justices who were held in extremely high regard. And if you go further back, at the beginning, the justices didn't ask questions at all. The questioning has accelerated through the 20th century. And I don't know that we will always keep the form of oral argument that we have now.
Do you think some of the conference discussion has telescoped its way into the oral argument discussion, in the sense that the questions you're asking the advocate and asking yourselves through the advocate are ways of having that discussion start there? That's the beginning of the conference, is the oral argument itself?
Not really. No, I know that that's one theory of oral argument, that it's a way in which the justices or the judges talk to each other. I have never thought that was really a legitimate use of oral argument.
Well, I just, in terms of this question about Justice Thomas, I mean, obviously he's a great contributor by virtue of what you've just described to the internal conference. But to the extent that the oral argument itself is an adjunct to that conference, if his voice is silent, don't you lose something by not having it available on a regular basis?
As I said, I don't think that we should use oral argument as a way of talking to each other through the attorneys. I think I personally don't find that to be a useful approach to oral argument. I know that people have said that that's something that they do, or that's something that is one of the uses of oral argument. I personally don't think that that's the purpose of it. I think the purpose is to ask the advocates to respond to real concerns that we have about the case individually. I find it useful to do that. Justice Thomas does not. And I can't say that my way of making up my own mind as to how to vote is better than his way. His way is consistent with the way John Marshall did it. His way is consistent with the way Joseph Story did it. That's the way the Supreme Court used to operate a long time ago. The fact that we don't do it now it doesn't necessarily make that a better way.
As the court moves to more and more questions, it's occurred to me that, I mean, obviously a good advocate knows to abandon the planned argument and respond to what the concerns are. It has occurred to me, as someone who's argued cases before the court, that we're at the point where it might make sense to stand up and say, may it please the court, we've submitted our arguments in the brief. I would like to respond to whatever questions you have, or if you would like any further elaboration, just shut up. Because you may have 3 or 4 issues, and it could be that you all know that 2 of them are going nowhere. It's a waste of time for me to be arguing, but there's actually an issue that you'd like to explore and may have some possibility. And that does that make sense? Or maybe not in literally that form, but to be that open to let the court lead the argument.
Well, when I was arguing cases, I was always happy to get questions. Sometimes I wasn't happy with the individual questions that I got, but I was happy to get questions because it told me what the judges or the justices presumably were really interested in. And they may not have been interested in my point 1 or my point 2, and they may have been interested in point 3 or something that I had not planned to talk about, or something that was a minor point in the brief that I wrote.
I often find that, especially in multi-issue cases and in the courts of appeals, I think typically there are more questions presented than at the Supreme Court level, that the lawyers don't necessarily know which of their arguments are the ones that really would reward discussion. And I think it's a help to them to say, well, counsel, let's talk about your issue number 3. Here's my concern about that. And I think that enables the lawyer to get right to the point, to address something that's that matters. I don't view it as a problem for counsel. I think it's a benefit to counsel.
There's a member of your court who's written a book recently giving advice to appellate advocates, and in that book and in some other sources, there's a proposition that the least effective argument is one that comes in and says, case X versus Y absolutely requires the court to reach this result, or just along string of cases and snippets of quotations, somewhat out of context from those cases. The most helpful argument is what?
The most helpful argument is one that sets out the arguments that are in the brief in a way that is different from what is set out in the brief, but summarizes them and boils them down to their essentials, so that the argument contributes something that the justice or the judge did not get from reading the brief, and does not get into details like that, quotations from opinions and things.
So it tells a compelling narrative.
Yes, a compelling legal narrative.
Right. One that obviously is anchored in the statute or the cases or the materials, but also one that allows you to get a head start on the way in which you might write the opinion if you're assigned it.
The one that boils the argument down to its essentials, presents it in a compelling way and in an understandable way, and makes sense of the position that the advocate is advancing.
You can't argue cases before and after being a judge of the Court of Appeals. Did the way you argue cases change after you had the experience?
I would hope I had a fuller, richer understanding of the judicial process and could be more empathetic, aware of the way the judge is likely thinking about the case. And I think that made at least the potential, it made it lived up to it, the argument a little bit more mature, more rich, and frankly more helpful to the court and hopefully to the client or the cause. Because I think all too frequently, and I've seen this very recently, I argued a case earlier this month in a court of appeals, and I was really stunned with the fact that very fine lawyers from excellent law firms were bound and determined to say what they wanted to say. Even though it didn't seem to mean you were reading the body language. It's very important for the advocate, reading body language. Is the justice or judge, or the judge is, really, am I connecting? Is this really a conversation? Or am I doing a little bit more of a set piece? Set pieces are very, I think, dangerous, because you're no longer really engaged in a conversation. And so I think just being very, as best you can, to be exquisitely sensitive, reading the language of the court, and really being very responsive. And I recall in this very argument, it looked to me as if one of the judges wanted to ask a question. So I did what I thought was polite. I just stopped for just a split second. It seems like an eternity. And it turned out the judge did not want to ask a question. So the judge, he was just very eager, but looked like he really wanted to ask a question. So I stopped. Because I noticed that it was a very long argument, multiple counsel, and I will just conclude by saying this. Some of the finest advocates in the country will talk over the judge or the justice, which is truly viewed in appellate advocacy circles as the unpardonable sin. You dare not interrupt the judge or justice. Seeing the justice not talking, I have another question.
There is a difference depending upon how large the panel is. The dynamics of an oral argument when there are only 3 judges is very different from 9. With 3, it really is much more of a conversation. I think that that counsel ought to take much more of a cue. With 9, very frequently, and I've been on that side of the podium. Very frequently, it's a bit miscellaneous, and it sometimes happens that one of the justices wants to go off on it has a tangent that is just not particularly helpful. And if all you do as counsel is respond specifically to the questions that are put to you, and you never get around to telling the court why you should win, you have not been a very good advocate. I think sometimes it's important to get away from the specific, respectful, fully responsive answer and get on to the point that you really need to make. And the larger the body, I think the more likely it is that that you as counsel need to be directive. The smaller the body, then the more coherent and conversational it's likely to be.
I want to move on to the considerations that you have as members of the judiciary for considerations of legitimacy for your opinion. What, in your mind, are the factors that make an opinion legitimate in terms of should be honored by, accepted by the people who are reading it, in addition to the fact that it has your signature on it?
Is it a case that's properly before us in every sense? Does it fall within our jurisdiction under Article 3, under the statutes? Are we applying a rule of law, and what's the origin and the basis and the legitimacy of the rule of law that we're applying? Are we applying the rule of law with full understanding of the facts and an appreciation of the arguments that are made by the parties? I think those are the factors.
Well, looking at those factors, whether the case is properly before you, whether you have a party who's got standing, whether the case is justiciable and not a political question, those factors sound like factors that are on the front end of the court's consideration of whether or not to take a case. Do those factors stay salient in your mind as you're hearing the argument as well?
Well, sure. Sometimes we will not take a case because we have doubts about jurisdiction, but sometimes there are other reasons for taking the case, or questions can come up after the case has been taken, or if it's an appeal, then we may note jurisdiction and consider it fully after we've taken it.
There's a whole theory out there by Professor Rosen at George Washington that your court is the most democratic branch. That in fact, even though you're not elected to your office, that the court, in the old line of Peter Finley Dunn, follows the election returns, right? Does the court have an eye toward democratic acceptability? I mean, we saw this, of course, historically, raised in the context of school desegregation cases, and the issue was raised profoundly there. To what degree was the court paying attention to the people and issuing its opinions? And presently, how large of a role is democratic acceptability as you write?
I think it depends on what you mean by the term. If you mean following the election terms, if you mean issuing opinions that are going to be popular, then that's something we should pay no attention to. If you mean acceptability in the sense of adhering to our proper role, because if we depart from the proper role, then our work will not be accepted. That's a very important factor. But we have a role to perform, and we should perform that role, and we were given life tenure precisely so that we don't pay attention to the election returns or polls or our sense of the pulse of the country.
So considerations that sometimes you see written about in the modern press about an opinion being culturally divisive is not a consideration that's properly before the court, unless it comes up in the context of, well, it's not properly before the court. Let me just leave it at that. Would that be a correct statement?
If it's properly before the court, then I think we have to decide it, and we have to decide it as best we can. So I don't think we can alter our opinion because we think this is going to be an unpopular decision.
One of the things, and I take Judge McConnell's admonition to not think about this in terms of just pure politics, but one of the things one noticed about the present term was that there were some notable absences in terms of there were no affirmative action cases, there were no religion cases, there were no cases of bong hits for somebody in particular. A lot of the cases that seemed to stir up a lot of trouble out here in the hinterlands were not on the court's docket. Was that accidental, or was the court saying, well, we'll give the nation a rest on those questions at the moment?
Well, I think we did have many controversial issues before us. We choose our cases, but we don't choose the menu of cases from which we make the choice. And there's tendency at the end of each term for the people who write stories in the press to try to summarize the term, and I think they don't take into account the fact that the particular combination of cases that we have during any particular year has a lot to do with accident. It has to do with the cases that are coming up through the courts of appeals and the state judicial systems, so it can be an accident. You could have a term with a lot of very controversial issues. You could have a term with not so many. I don't think it's a choice on the part of the court.
This is an hour portion of the discussion. You can watch it in its entirety at cspan.org. Just click on America and the Courts under the C-SPAN series link. Join us next week for America and the Courts, Saturday evening.
Okay. So we have about 10, 15 minutes left. So what do you guys think? Did you get any new insights into how you might want to deliberate, things you might want to consider, or the way that, for example, the conference, the post-argument conference relates to the judicial opinion? Yeah, Tiffany? Oh, you're still muted. I got you.
Can you hear? Okay.
Yep.
I would say that the insight that I gained from the video would be to remain flexible. I was actually shocked to hear that they actually changed their opinion so drastically after they had the conferences. So I would just say maybe remain more flexible.
Yeah. Yeah, and even change their opinions from the conference vote to post-writing. That post-writing, they may decide, no, that's not going to work. Katie.
I thought that it was interesting that they said that sometimes vagueness is the best thing to do, especially if it's a newer topic. So that way, if it comes up again, you can work from that.
Yeah, so they have sort of a long game. They have a short game with that particular opinion, and then they have sort of a long game on the issue as a whole. If they feel like it's not sufficiently developed, they may say, you know what, we'll do a little of this and then let it develop later. Yeah. Rob.
Two things. The first thing is more of a question. Can you post the link to this video in Twin? Just so
yeah, absolutely.
Okay, great. And what I found interesting was when Judge McConnell, when he went on to say the court does a disservice when they jump the gun by issuing clear rules when they don't really even know enough on the rule or have enough expertise on the rule, and they set the rule in place.
Yeah. So again, kind of linking to what Katie said, that sometimes they are intentionally vague to avoid that very thing, to avoid being too specific. Yeah. Other thing. Oh, and you said you had you asked me the question. Okay. Other insights. Anything that was surprising to you? Anything that you had heard maybe that you were surprised to have confirmed that maybe you had some doubts about? Anything? General thoughts or impressions of of hearing these judges talk about opinion writing. Chris?
One thing I was going to say was, as far as when they were talking about the audience, that I found it actually interesting because I didn't think of it like this prior, but the majority writer is actually writing to be in concurrence with the rest of the majority as opposed to writing his majority opinion, which is what I kind of, assumed, I guess.
Yeah. Yeah, so the majority writer, the function of the majority writer is to reflect the majority opinion rather than someone who is elected to just write the majority as they see the majority needs to be written. So it's a much more, it's more of a service than a privilege. And yeah, it does add an extra audience in addition to the audience that the court as a whole is trying to appeal to. It gives them the audience of their peers that they have to satisfy that they've represented them well. What else did you guys, something you learned that you didn't know before? So let me see now. I doubt that I can because my computer is still hung up on this one thing the same way it was. But let me see if there's any shot that I can share this chart with you. Yep, just not going to happen.